Well, I'm reliably informed by the crowd here that it's 5:30 p.m, so without further ado I'll start. My name's Richard Sergi. I'm a barrister here at Greenway Chambers and also a mediator. I've been at the bar for over 25 years and have been mediating for a little while now. Welcome to this seminar, Mediating Ethically, and I've subtitled it Don't Be Too Loose with the Truth or Too Clever by Half, partly to make it a little more interesting than it might otherwise sound. First of all, by way of introduction, as we all know as litigators, mediation's become a ubiquitous component of contemporary legal practice in this state, certainly over the last 20 years or so. And you'll see there that I've set out a few basic propositions. That is, the notion of mediation and its practice has developed reasonably quickly over those last 2 decades to the point where a prudent legal practitioner, I think, should ensure that she or he has at least some basic understanding of the process and potential pitfalls, particularly so for lawyers and others involved in litigation. Like most legal matters, the topic of mediation is capable of filling a program of seminars over many days, let alone a single session. This seminar merely scratches the surface of one particular issue, the issue of ethics and mediation, and happily the topic satisfies one of the essential professional development criteria, which is why people are here and viewing keenly online, no doubt. For courts, mediation has become an important component of case management and case load. From time to time, or maybe often, depending on the nature of your professional practice, legal practitioners are retained to advance at mediation the interests of a party to a dispute. That is, solicitors and barristers are retained to isolate issues, develop options, consider alternatives, and reach an agreement which accommodates the needs of their clients. Now, why is ethical practice at mediations important? I will endeavour to touch on some of the reasons why. The efficient and efficacious administration of justice relies on lawyers complying with their duties and obligations, not just in court, but outside of court. So too, the proper administration of justice relies on lawyers adhering to the rules of professional practice. These duties, obligations and rules extend to conduct at mediation, sometimes a thing that is not foremost in people's minds when they're engaged in mortal combat in some small room in the city somewhere, protecting their clients' interests. From a legal practitioner's point of view, statutes and professional practice rules require a lawyer to act ethically when advancing a client's interests at mediation. In short terms, legal practitioners are required to do 3 things: not to mislead an opponent, to act with candour, and to deal in good faith. That's by no means an exhaustive list, but I will now draw your attention to 4 matters to consider when approaching how you conduct yourself at mediation. The first matter relates to the Civil Procedure Act 2005. And I've set out there a few sections and parts. Section 4 and Section 1 set out the application of the Civil Procedure Act to various jurisdictions. It applies to, for example, all civil jurisdictions in the Land and Environment Court. It applies to the Supreme Court in all its jurisdictions, the Industrial Court, the District Court, and to certain aspects of the local court. And you'll find where it applies in Schedule 1 and Section 4 of the Civil Procedure Act. Part 6 of the Civil Procedure Act addresses case management and interlocutory proceedings. Section 56 is well known to litigators, and it sets out the overriding purpose. And this is a theme that runs through how the court views the approach that practitioners should take to mediation. That is, to facilitate the just, quick and cheap resolution of the real issues in the proceedings. Subsection 3, which is not reproduced there, actually it is, but it says 2, should be subsection 3 of Section 56. A party to civil proceedings is under a duty to assist the court to further the overriding purpose, and, to that effect, to participate in the processes of the court to comply with directions and orders of the court. Self-evidently, I would add, if a court orders parties to participate in mediation, the court expects them to do so in good faith and with the overriding purpose in mind. Part 4 of the Civil Procedure Act expressly addresses the mediation of proceedings. And mediation is even defined in section 25 as a structured negotiation process in which the mediator, as a neutral and independent party, assists the parties to a dispute to achieve their own resolution of the dispute. Now, the fact that mediation is referred to in the CPA and defined affirms, in my view, its significance and importance in civil procedure. Section 26 sets out the power of court to refer a matter to mediation. Section 27 succinctly describes the duty required at a mediation. Duty of each party to proceedings that have been referred for mediation to participate in good faith in the mediation. Now, the term good faith is not one that is amenable to exact definition, as many terms are not. For practitioners, however, the term does connote some basic aspects of professional behaviour. And if I could interpose here with a bit of history, many moons ago, in 2001, there was massive litigation known as Idaport and National Australia Bank, where a computer systems group was suing NAB for $50 billion in those days for alleged breach of contract over the bank's failure to develop and market electronic trading platforms. Now, at the time, there were dozens of interlocutory decisions made by Zona Justice Einstein in hearing the matter, and one of those related to going to mediation, wherein at that stage there was only one witness over many days and weeks had given evidence, so the plaintiff made application to the court for the matter to go to mediation, and in those days that's how mediations generally occurred. The parties had to apply to the court with reasons why it should go to mediation. And one of the bugbears in those days was the fact that if a party was unwilling to go to mediation, the worry was that they weren't going to participate in good faith, and the court had to wrestle with this notion in the early days of mediation as to how they would get people to participate in good faith. Now, it was on Justice Einstein in Idaport, I think it's decision number 21 in 2001, referred to an earlier judgment of his, and he said, "To my mind, without being exhaustive, the essential or core content of an obligation to negotiate or mediate in good faith may be expressed in the following terms," and he took a slightly equity division approach to this: to undertake to subject oneself to the process of negotiation or mediation, and to undertake in subjecting oneself to that process to have an open mind in the sense of a willingness to consider such options for the resolution of the dispute as may be propounded by the opposing party or by the mediator as appropriate, and a willingness to give consideration to putting forward options for the resolution of the dispute. In other words, Justice Einstein was saying you've got to bring a proper approach to this in an open mind, and you can't just say, we'll turn up only because the court told us we had to. So that's a bit of background. Now, the second consideration that you should bear in mind when approaching how to act and act ethically at a mediation is the Legal Profession Uniform Law Application Act. Now, Schedule 2 of this Act addresses costs in civil claims. Clause 2 of Schedule 2 prohibits a law practice from acting unless there are reasonable prospects of success. This, of course, flows through to prospects of success, not just at trial, but at mediation. And as you may well be familiar with subsection 1 there, a law practice must not provide legal services on a claim or defence unless those responsible for the provision of the services concerned reasonably believe on the basis of provable facts and a reasonably arguable view of the law, the claim or defence, as appropriate, has reasonable prospects of success. And then it sets out how a fact is provable. Now, in the event that a costs argument arises in the context of a mediation, usually a failed mediation, I'd suggest that it's a poor starting point for those seeking their costs to have as a question mark over whether the party or a practitioner has participated in a mediation in good faith and ethically. it would be open, I suggest, to your opponent if you're arguing about costs to say, well, look, you know, you didn't approach this thing in good faith. And one of the reasons was there weren't provable facts and a reasonably arguable view of the law, etc., etc. So that's the second consideration I ask you to bear in mind. Third one are professional conduct rules for solicitors and barristers. The Legal Profession Uniform Law Australian Solicitors Conduct Rules. Rolls off the tongue. Clause 22 addresses communication with opponents, must not knowingly make a false or misleading statement. This is also good just to review anyway for, you know, when you're out and about town dealing with matters. A solicitor must take all necessary steps to correct any false or misleading statement made by the solicitor to an opponent as soon as possible after become aware of it, and you must address another solicitor's or person's error. Just bear these in mind when we come back to a case later on in the seminar. And clause 34 addresses dealing with other persons. In other words, not just your dealings with your colleagues, but with people who may not be solicitors and or barristers. Professional conduct rules for barristers. Now, clause 4 sets out a number of guiding principles that really, A to E there, relate principally to barristers' roles as specialist advocates, more particularly D and E, that is, you have a duty to the court and to other barristers in relation to forensic judgments and the like. More generally, the conduct rules applicable to barristers are consistent with those applicable to solicitors. So you'll see there clause 49 and clause 50 mirror the invocations that the rules have in relation to solicitors as they do for barristers. In other words, you can't knowingly mislead people, and if you do so, or you make an error, you should correct it as soon as possible. So that's the third consideration. Fourth consideration is the model litigant policy for civil litigation. And this is one that's particularly important for those of us and you who do act for the state of New South Wales and its various iterations. Consistent with the approach in the statutes, the state of New South Wales has adopted a model litigant approach to litigation. Back in 2008, the policy was approved for adoption. Revised policy was released on the 1st of July 2016. I have the technical assistance coming. Clause 2, which you cannot see there because that's the previous slide, states, and it's in simple terms, the state and its agencies must act as a model litigant in the conduct of litigation. In short terms, the model litigant policy is designed to provide guidelines for best practice for government agencies in civil litigation by providing principles for maintaining proper standards in litigation and the provision of legal services in New South Wales. And of course, that includes mediation. The model litigant policy is founded upon the concepts of behaving ethically, fairly, and honestly to model best practice in civil litigation. And that approach is reflected in the model litigant policy, which requires the New South Wales Government and its agencies, and of course those who act for them, to deal with claims promptly, not to take advantage of a claimant who lacks the resources to litigate a legitimate claim, to pay legitimate claims, to avoid litigation where possible, and to keep costs to a minimum, and if required, to apologise. Now, there are two cases which I want to take you to, and I'll make sure there's a paper. Oh, are we back on? We are. Thank you for that participation from the crowd there. There we go. Two cases. That's the model litigant policy, and just pausing there for a moment, the matters I just addressed you on. You'll see there that the policy is really, it's very short if you ever want to have a look at it, mercifully, but it's pretty clear that it reflects acting fairly and appropriately, just as the practice rules do and the legislation. moving on to two cases. The first case is a case that you may well be familiar with, involving a barrister and a solicitor in Queensland, Legal Services Commissioner Mullins and Legal Services Commissioner Garrett, and the second case is Murphy. Dealing with Mullins and Garrett, first of all, this really was a case of, I thought when I read it, of looser the truth and too clever by half. Now, the facts of the matter were that there was a motor vehicle accident in Queensland. The injured person was seriously injured. They were rendered paraplegic. It might have even been quadriplegic, I apologise. Statutory timeframes were complied with in relation to providing particulars. Claimant disclosed to his solicitor confidentially an unrelated cancer diagnosis which significantly shortened his life expectancy. Now, at mediation, the defendant motor vehicle insurer relied on expert reports in relation to life expectancy which were based on the prior or previous facts of the matter, not including the fact that the plaintiff had been diagnosed with cancer. So what really happened was the insurer proceeded on a wrong assumption about the injured person's life expectancy because his cancer diagnosis hadn't been disclosed. Mullins, the barrister, and Garrett, the solicitor, were found to have intentionally and fraudulently deceived the insurer and its lawyers about the accuracy of fundamental assumptions made in respect of life expectancy that were wrong in light of the applicant's recent cancer diagnosis. Both the solicitor and the barrister knew the insurer settled the claim on a wrong assumption of a material matter. Both were fined for professional misconduct. Now, a material fact in both cases was that the practitioners had made representations to their opponent at the mediation. And those representations were critical to important parts of the claim, that is, life expectancy, and they were relied on by the defendant. And they had become false by the time the mediation was conducted, a fact known both to Mullins and Garrett. They were obliged under the professional conduct rules, which I've taken you to, and at common law to correct the false statements. The claimant and the legal representatives continued to rely on the assumptions which were not correct. The tribunal was directly concerned with the duty of disclosure owed by legal representatives to their opponent. Remaining silent was a practical deception. Now, the next case, we're racing through this. The next case is one that has some interesting facts. It's a case involving a police prosecution which didn't go anywhere, and the accused was then became the plaintiff and sued the state of New South Wales. It was a matter that came before His Honour Justice Harrison on an interlocutory matter. Now, the facts were that the plaintiff claimed damages from the state of New South Wales for wrongful arrest, false imprisonment and malicious prosecution in relation to alleged sexual offences. The plaintiff's arrest and charging arose out of activities of persons interested in what's known as bondage, domination and sadomasochism. The two complainants, who were given the pseudonyms AC and SH, along with the plaintiff and a number of other people involved, were subscribers to a blog called FetLife. Some of you may know of it, I of course didn't. It's a blog for people interested in BDSM which publishes profiles of members of the group that outline personal details and their fetishes, and that's how that's the circumstances in which the accused, as he was then, became the plaintiff, and the complainants came to know each other. Justice Harrison ordered the parties to mediate the plaintiff's claim for malicious prosecution. A mediation took place, and he outlined the relevant facts of the mediation, and they are these. The mediation commenced at 10:07 a.m. and it concluded at 10:17 a.m. It was unsuccessful. In the events that occurred, Mr. Murphy, that is the plaintiff, the applicant on the motion, sought orders in accordance with the notice of motion filed the day following that the costs thrown away in the circumstances be paid by the state forthwith. Now, that was because at some point it was made known to Mr Murphy that there's no way on God's earth the state of New South Wales, i.e. the police, were ever going to pay him any money. And the suggestion was, well, you didn't mediate in good faith and we want our money for the costs thrown away. Now, Justice Harrison, and I'll come to this quote in a minute that's up on the screen, before he stated what he stated there on the slide, said he considered Section 27 of the Civil Procedure Act, to which I've taken you earlier, and the power to order mediation. And he said, as a matter of generality, it could not, in my opinion, be a breach of the duty of good faith for a party to attend at a mediation and refuse to make or to consider any offer of settlement other than that the opposing party capitulate entirely and pay costs. For example, if the opposing party's case, objectively assessed, were entirely without merit and hopeless, it could hardly be a requirement of the good faith provision that a party must agree to pay money or to make some other contribution to a meritless compromise. And that makes sense. If it were not justified on the basis to do so, even allowing for the vicissitudes of litigation, it cannot without more amount to an absence of good faith for a party to seek an adjudicated vindication of its position in litigation where it believes or has been advised on reasonable grounds that it should do so. In other words, it's a legitimate approach to take, to say, look, we've been ordered to go to mediation, we'll go to mediation, but then when you get to mediation, you just say, look, on the basis of the reasonably arguable law and the provable facts, I'm not going to offer any money. That's reasonable. You won't be, if the circumstances justify it, there's no problem about negotiating in good faith. There is obviously a distinction between that and just simply saying, well, we're never going to pay you money, we don't like you. In cases like this, we just don't pay up. There is a distinction, albeit slight, but only could be determined really on the facts and evidence. Now, a question that remained, having said what I've just outlined to you, a question that remained was unresolved due to a lack of evidence, however, was the question of whether good faith required the defendant to give notice of its approach that it was going to make no monetary offers, and if so, how much notice was required. Justice Harrison explained, and here I refer to how he explained it. It would not, in my view, be controversial to expect that one party to litigation should not be permitted to allow the other to incur costs on the basis of an assumed set of facts that the first party knew to be unfounded. For example, if it were hypothetically the position in the present case, the State of New South Wales, as a model litigant, had formed the view it would never pay money to Mr Murphy unless ordered to do so by the court, and that this view was formed well in advance of a scheduled mediation, it would, in my opinion, be inappropriate to say the least, and probably misleading for the state not to make that position clear to Mr Murphy or his solicitor in a timely way without undue delay, so that unnecessary costs and preparation for it could be avoided. So, on the one hand, Justice Harrison is saying, look, you can take that approach if it's reasonably held and reasonably arrived at, but if you do, you should do what you can to avoid allowing the other party to incur unnecessary costs, where it's open to you to ensure they do not incur unnecessary costs. Now, I can't tell you what happened because due to issues related to the admissibility of evidence on the application, there was an affidavit that was filed on the application by the plaintiff. It was objected to. Everyone got a bit hot and bothered and tired, and His Honour Justice Harrison stood the motion over to the hearing of the principal proceedings. So it wasn't really determined. Now, plus it's just an interesting case on its facts. Practical takeaways. I know everyone wants practical takeaways. There are a number of reasons why a legal practitioner should be careful to act ethically at mediation. It has a clear statutory basis. Acting ethically at mediation is a requirement of professional practice rules. If your client is the State of New South Wales or one of its many agencies, the model litigant policy mandates ethical participation in mediation. And a failure to adhere to proper ethical practice may have unhappy consequences for the practitioner, either in relation to costs or professional sanction. So there were some good reasons why we shouldn't be too loose with the truth or too clever by half. What practice should be adopted or avoided? Some are obvious, all are worth stating. From the very basic, do not make a false statement. If you do, correct it. Do not knowingly or recklessly mislead other parties attending a mediation without having authority to settle. That is an important one, which does drive people crazy sometimes in different jurisdictions. I know in the Land and Environment Court, sometimes people turn up and say, "Oh, we can't settle it." I mean, there's an argument that they haven't turned up in good faith if that's the case. Do not take advantage of another party's error if to do so would advantage your client without a proper foundation in law or fact. And the unhappy situation of Mr. Mullins and Mr. Garrett loom large there. Do not make unfounded allegations. For example, just as people sometimes used to do more often than they do now, look, your case has no merit, it's rubbish, it's no good, it's hopeless, we'll see you in court. That sort of attitude is different and in distinction from what His Honour Justice Harrison was referring to in Murphy, where he said, look, if you've got a reasonably arguable view of the law, provable facts, you've come to an arguable position, well, that's fine. But if you just turn up with a bad attitude, that's a bit different. Finally, do not intimidate or threaten another party by making statements which exaggerate rights or entitlements or sanctions. And one that's often used as an example is, this case you're running, if you're in the Supreme Court, it's not going to get over the limit that you need to get over to recover all of your costs, or it's otherwise going to attract some sort of sanction of the court because it's just no good. In other words, there has to be a proper basis for any claim that you make in relation to not just your colleagues, but as we've seen from the practice rules, other people. I've raced through this. In short, don't be loose with the truth. Don't be too clever by half. Ultimately, such conduct may not in fact be in the best interests of your client. Or worse still, it can lead to complaint and professional sanction against you. That's it. Mercifully, it's concluded. Someone who I've mentioned here before, when I'll just say they, I'll use the pronoun they, were president of the Bar Association, said when I was attending one of these things that attendance is compulsory but questions are not. But having said that, I'm happy to accept any questions. Oh, there's a question.
That model litigant policy, is that enshrined in law?
No.
So can you take that out?
Beg your pardon?
Can you take that out in terms of if a state authority is...
Look, sometimes people do. Plaintiffs do in, for example, medical negligence matters. They do throw it in there from time to time. It's something that, usually they'll be suing local health districts or VMOs, doctors and things like that. They will refer to the model litigant policy. It often gets a run in various places, but in my experience, those acting for the defendants in those cases are well aware of the model litigant policy and don't shy away from it. It seems to have more force in some circumstances than others, but certainly it's a live issue, and their clients take it pretty seriously because they in turn have to answer to people higher up the chain. And the people at the very top of the chain, ministers, don't like adverse publicity about the state doing the wrong thing. So if you're at the very bottom of the chain, as we usually are, it's a good idea to bear that in mind. That ultimately, if you do the wrong thing, worst case scenario is you could be on, page 3 of the Telegraph or something. Okay, so it's not legislated, but it's certainly something that the state expects you to follow. We conclude.